Hi, good afternoon, or depending on your time zone, good morning. My name is Moses Park. I'm a barrister based in Hong Kong, practicing from Liberty Chambers. I'm a member of the HK45 steering committee. Thank you everyone for joining us today. I'm sure many of you attending today's Fireside Chat are well aware of HK45, but for those of you who are not so familiar with us, I'd like to give you a short introduction. HK45 is formed under the auspices of the Hong Kong International Arbitration Center. We are a group of professionals who are under 45 years of age and who are currently practicing international arbitration or are interested in the practice of arbitration. With that said, regarding the age being under 45, there is a caveat to this. We welcome everyone to join us as long as you're young at heart. We have our LinkedIn page, so please follow us so that you can receive various announcements for events and social gatherings we organize. Before COVID-19, when things were normal and we were able to travel and freely meet for drinks, what we did was to invite senior arbitration practitioners, renowned arbitrators, and judges from different jurisdictions to meet with us, younger generation practitioners, so that we can learn from them over drinks. But unfortunately, due to travel restrictions and social distancing, we are not able to invite senior practitioners to Hong Kong to meet with us. But fortunately, with video conferencing tools, we're now able to invite senior practitioners from anywhere in the world to share with us their wisdom and knowledge, and for us to learn a little more about their professional and personal life and their career path. In our virtual Fireside Chat series, we have invited senior female practitioners from different jurisdictions. It is our initiative to showcase female talent in arbitration. We're grateful to our guests of honor who have accepted our invitation to speak to us. Today's chat is the fourth of 6 in the series. It gives me a tremendous pleasure to introduce our guest and speaker for today, Winnie Tam SC. Winnie is a great friend and a great personal mentor of mine. She really needs no introduction as her reputation precedes her, but I still need to do my job. So here's a little bit about Winnie. She's one of the leading SILs here in Hong Kong, practicing from Liberty Chambers. She's one of the best, if not the best, in intellectual property and patent litigation. She conducted the very first patent trial in Hong Kong, and Winnie was the first female IP specialist to be appointed senior counsel in our Hong Kong bar. She served as bar chairman from 2015 to 2017. She often sits as an arbitrator in international arbitration cases and has been appointed as sole arbitrator, party appointed arbitrator, and presiding arbitrator. And as an aside, Winnie has a deep appreciation for music and is a great singer. Winnie will be interviewed by Hugh Cam, a fellow brother at the bar. It is also my great pleasure to introduce Hugh, who is our moderator for today. Hugh has sat as arbitrator and acted as counsel in arbitration cases. He's currently serving as a steering committee member of HK45 with me. And he previously served as a council member of the Hong Kong Bar, and he was the chairman of the Standing Committee on Young Barristers. And last November, I may embarrass Hugh a little bit, he was named by Prestige magazine as one of Hong Kong's 40 under 40. He was definitely a rising star, both at our Hong Kong bar and in the arbitration space. With that, I'll now hand over to Hugh. Thank you everyone for joining us today.
Thank you, Moses, so much for that kind introduction. Good afternoon, or rather good morning and evening as well to our colleagues from Hong Kong, the region and beyond. Today, of course, the Fireside Chat is with Ms. Winnie Tam SC JP, as you've heard, and we really do welcome Winnie and thank her for taking time out of her busy schedule to be with us. Just perhaps a few housekeeping matters before we begin. The first, of course, is that this webinar will last for between 45 minutes to an hour. And we do very much welcome questions. As you will see at the bottom of your screen, there is a question and answer button. So do feel free to let us know your questions, and we'll either ask them during the course of the conversation or towards the end. And of course, perhaps one more thing is the nature of this Fireside Chat is really to learn from Winnie, to know the persons behind these arbitrations that we're all involved in, rather than perhaps to talk about the law or to talk about recent arbitral developments as such. So without further ado, Winnie, perhaps let's start at the very beginning, as it were. Did you always know you wanted to become a barrister, or was this something you found for yourself later in life?
Thank you, Hugh. I just want to say what a great honor it is for HK45 to have invited me. I've never known until Moses talked about it just now that people aged over 45 could become a member. So maybe I'll apply.
Very welcome to do so.
Thank you very much. To answer your question, I can't say that I have always wanted to be a barrister, because when I was a kid, I was very much interested in reading news about courtroom drama and court cases. I was very interested in it, and I read every bit in the newspaper there was about court news. And to that extent, I was very interested, but I never dreamt that I was going to become a barrister myself. But when I was in law school, I started doing summer jobs here and there, like all of you have, if you're a practitioner. And in the course of doing various summer jobs, I found out that my interest was very much at the bar. And by elimination, I decided that I would like to come to the bar. And I was also interested in law drafting at the time, but unfortunately, the Attorney General's Department at that time did not take on pupil barristers from the private sector. They would only allow their own civil servants who have been to read law to a pupil at AG's chambers. So I had no choice but to come to the bar to become qualified first. And after I joined the bar, I decided that maybe the private bar was much more suitable for me.
And then, of course, we understand that for some time you were seconded to a set of chambers in London specializing in intellectual property law. And of course, you're known for your expertise in that field. I mean, did specializing in a particular area of law help you break into these circles, both in litigation and arbitration?
Well, when I was doing my year out in London, I was already a junior barrister practicing in Hong Kong. So I practiced for 2 years. During which I did a mixture of work, civil and criminal. And at the time, I must admit that I found the criminal work very interesting, because it allowed the junior barrister to have a lot of action in the lower courts. And that was how my advocacy skills and cross-examination skills were honed. So I think that was a very wonderful period of time. But after 2 years, I decided that I really must move on, because it is very, very easy to be sucked into a busy criminal practice and not be able to jump out at all. So after 2 years, I made a plunge. I took a plunge of leaving my practice altogether. I took some money, some savings with me, and then I enrolled for a course, for an LLM course in the University of London. And then I started pupillage, and whenever I could, I would go and attend the LLM courses, the lectures there. And I think that really helped me, because I had a very clear purpose at that time, and I wanted to do specialist work. At the time, it was not quite possible for you to get instructed to do intellectual property work unless you have demonstrated that you have either done substantial pupillage there in the area, or have read a degree there. But in those days, if I wanted to get into plaintiff's intellectual property work, the obvious choice was to really, to be immersed in it for a year. And that achieved the purpose of doing that area of work, which I liked very much at the time. Well,
that's certainly very interesting. And I think our young practitioners do need to think about whether they would prefer to continue as general practitioners or specialist practitioners, and that's something to bear in mind. One thing we do find in these webinars that our audiences are very interested in are war stories, the sort of defining challenges, defining victories, defining mentors that you meet along the way, especially early on in your career. Are there any for you that you would be able to share with us?
Well, perhaps there were too many to share. I mean, in the courtrooms, there are a lot of drama as usual, and those are as exciting as in the arbitration tribunal. I'm sure many of you have come across defining moments of your career in the arbitration tribunal as well. But in the courtroom, because of sanctions that the court could impose on not only the parties, but the lawyers themselves, it tends to be a more sort of strenuous and intense business. And I really liked that action. But after years in the courtroom, I also enjoy very much the collegiate atmosphere of an arbitral tribunal and the more collaborative atmosphere in an arbitration tribunal. So I don't want to take up all the time by sharing war stories, because some of them may sort of ramble on a bit, but perhaps one particular one I sometimes tell to people who are interested is once my opponent in a trial, he was grilling a particular witness for 3 days, and the issue over that was he was an independent designer of packaging, and my opponent wanted to run the case that he had copied his client's packaging in designing the packaging for my client. And in fact, well, our case was that the opposite was true. So their client had copied the packaging that was designed by this independent designer who was commissioned to create the packaging. And he didn't bother to dig out all the development materials, which would have proved the case for us. But instead, I mean, he just came and told a story, which wasn't believed by my opponent. And then after 3 days, he got fed up because he had work and he had to go to work, and he was detained in the courtroom for too many days. And when counsel didn't let him go after the 3rd day, he decided that he was going to go to his mother's home and dig out everything to show that there was a design process which was his and his alone. And he turned up in the courtroom the next day late, making us think that he was fed up and he didn't want to come anymore. But instead, he turned up late with a whole box of materials that completely proved our case. So, I mean, the lesson to be learned is that you always have to choose your witness to grill. I mean, after a while, if you think that, you can't get anything more out of him to help your case, you have to give up. Otherwise, consequences will follow.
Quite true. And of course, also that you should keep all your designs at home and everything from, all those years back, they might come in handy one day. You mentioned, of course, also, being involved in many arbitrations, of course, and enjoying the collegiality of the tribunal. And that's something that many colleagues from around the region are interested in hearing about as well. I think perhaps to start more towards the beginning, I mean, how did you first break into the arbitration circle? Because this is important for many young practitioners. It is very difficult to break in. So sort of any tips and how you did so would be interesting for us.
Yes, well, it was not done on purpose, I must say. I think I was happy to continue to do intellectual property and commercial litigation as a barrister. And I was also judging from time to time as a deputy judge and then later as a recorder. So I was quite enjoying that area of work, but I was drawn into learning about arbitration and discussing issues in arbitration in my capacity as bar chairman between 2015 and 2017. When it became known to the DOJ that, well, I mean, we really must enlist Winnie's help because they were trying to promulgate this law, I mean, the amendment to the arbitration ordinance, making intellectual property matters arbitrable. So in that context, I first came into serious contact with arbitration as a study and as a subject, as a topic in legal practice. And I became very, very interested in it, but never thought that I would shortly be actually doing real arbitration. But when the prospect presented itself, I was already trying to hone my skills in arbitration, trying to sort of get qualifications, fellowships here and there. And then the opportunity just presented itself. It was the first case I did was when two arbitrators who can never agree between themselves on any issue, they had to nominate a chair in the arbitration. And after going through a long list of names and they couldn't agree on, somebody mentioned my name and suddenly they agreed. So I was given this first opportunity, which I was very, very grateful for. So I had the opportunity to learn from these very experienced practitioners. And then more opportunities came when other arbitrators who were more experienced decided to give me a chance to work with me. Which I really enjoyed very much and am very, very grateful. So my way of so-called breaking into the practice was through some people who are more experienced having some confidence in me, or who thought that I had something to contribute in the constitution of the tribunal. Sometimes it could be something that has to do with intellectual property. Other times it is something to do with bilingualism. Knowing that I can read and write Chinese and my Putonghua is okay. So I think those are opportunities for me, which I had the pleasure to take up.
Great. I just clarify for our foreign audiences, you mentioned the DOJ just now, and that's the Department of Justice in Hong Kong that Winnie was referring to. Going back to what you were saying about being able to contribute, especially a niche or a specialty, to the arbitral tribunal, are there any tips practically you would give to young practitioners appearing before tribunals on how to handle arbitrations before tribunals?
Yes. Well, in my experience, which is also the experience of those who sit with me and agree with my views, so I'm not only drawing upon my own view, but also the views that I gathered from other arbitrators sitting with me. It is always helpful to receive very structured submissions, which are not overly OTOs, but are succinct enough for the issues to be clearly presented. Now, I cannot overemphasize the help that a structured and succinct piece of legal submissions would give to the tribunal, particularly the member who has to draft the award, because the structure is plays a large part in helping the crystallization of the issues, and so that there is no confusion over what has to be decided and what sub-issues need to be gone through in order for the main issues to be decided. And secondly, a tribunal never finds helpful overly argumentative counsel representing parties. If a counsel on one side is seen to be overly argumentative, even on small procedural issues, then it leaves a kind of taste in the mouth of the arbitrators, if you know what I mean. And when it comes to things that matter, it's that kind of taste in the mouth is not going to help the counsel who has been overly zealous in sort of arguing every little procedural point, sometimes unnecessarily. Now, it is very important, of course, for counsel to be seen to be fighting for their clients, but I think you need to pick your battles.
Yes, I mean, one tends to find that being reasonable actually gains points in tribunals and indeed in courts too. And that leads me to ask, because you mentioned as well earlier that you've sat as a recorder and as a deputy high court judge on multiple occasions. How would you compare those two experiences? Are there any differences that are noticeable? Because again, of course, many of our audience members do practice dispute resolution more broadly and not just arbitration.
That's a very good question, Cam. I think the main difference is that the court has a lot of powers, which it would exercise in accordance with the rules of procedure and law, of course. And the court is expected to exercise such powers when the occasion arises. Whereas for the arbitral tribunal, the culture is completely different. So for example, for procedural matters, the tribunal is always expected to consult the parties. And it is only where the parties cannot reach agreement that the tribunal would step in and be sort of more decisive about matters. I think in that regard, somebody in my position has to switch gear, so to speak. And one has to, I constantly remind myself when I'm sitting in an arbitral tribunal that I shouldn't be behaving like a judge and not giving reasonable leeway to the parties and not allowing sufficient opportunity for the parties to present its views, even on procedural matters. As regards court proceedings, the other feature is that usually, I mean, in 90% of the cases, it has taken a long time for it to come on. So the parties will have had a lot of time, or they may have even left their case on the side. Even the counsel will have left the case alone for a while before they pick it up and prepare for a trial. Whereas in an arbitration, it is usually more continuous. So there is never expected to be any sort of lengthy period when the case is just sitting there waiting to come on for hearing. So I think that makes a big difference in the sense that when the case comes on for hearing, usually you will find that everything that has happened in the past in terms of procedure or even interlocutory applications are still very, very much fresh in the minds of the parties and the tribunal. And I think that is a factor which helps a clearer view, a clearer overall view of how the case has developed. And sometimes it will help making the right decision as well. Whereas at the trial judge, most of the time in our system, they don't have a view of what has happened before the case come on to trial. So it is just one phase of it they would be sort of looking at, rather than having an overall view as if you're taking the case from the beginning and knowing how it's developed every step of the way.
Yes, I mean, I follow you, and I agree that both in terms of continuity and then in terms of speed, there is something to be said for our courts to really learn from arbitration in that sense. You mentioned just now switching gears between being a judge and then being an arbitrator. And there's another gear that you, of course, switch in your practice, which is to switch from being an arbitrator to being counsel in arbitration. How do you make that switch? Are there any differences you feel in your approach, and do you enjoy one over the other, for example?
Well, it's like playing different roles in the same drama. Of course, the work of counsel is very, very different, but having the different roles of arbitrator and counsel and judge definitely helps, because it helps you have an idea of how the tribunal will receive some submissions, and you will cater for the likely reaction of the tribunal when you make some submissions. And likewise, in the courtroom, it is always helpful to have been on the bench sometimes. It gives you a much better view of how a court is likely to think and to operate when receiving submissions or when your case is presented in a certain way. So I always encourage my colleagues in chambers to go and sit as deputy judges, even in the district court or in the high court, if they think that they would like that view, because it really helps in their career as barristers. And for counsel, normally people enter into the arbitration circle first as counsel, acting for parties, particularly for practitioners of a younger age. You would want to be in a team representing one of the parties. And then in time, you would like to, become a barrister, become an arbitrator and get the appointment. And normally, the HKIC is doing a great job in ensuring diversity. So we are looking for, I'm now serving in the appointments committee, and I can tell you that we are indeed actively looking for opportunities to nurture and bring up younger arbitrators. So there is no question of any sort of closed circle and an unwillingness to include new arbitrators into the circle.
Well, I do think our foreign audiences and obviously our audiences here as well are very grateful to hear that, especially because, you know, breaking, as I mentioned earlier, breaking into the circle, it can be quite challenging at times. You mentioned diversity just now, and I think that's obviously an issue that we need to talk more about, especially given what's going on around the world. That brings me to the fact that, of course, that you are, of course, a female senior counsel. There are not too many, about 10 to 15 in Hong Kong only. What would you say to young female practitioners as to how to break that ceiling and move up? Because as you will know, in Hong Kong, certainly, the law schools are probably made up of about 70 to 80% young female practitioners right now. But in the senior levels, as I mentioned just now, we don't see those numbers or nearly those numbers at all. So what would you say to the young female practitioners as to how to persevere and move up?
That again is a very good question. I have been sort of thinking of this problem for years and trying to feel the way through it. First of all, a lot of times the existence of this glass ceiling is very much something that exists in the mind, but not in reality. Sometimes it exists in reality, but it depends on how a female practitioner conducts herself. Now, I observe that I have been looking at the figures of the bar, for example, and find the kind of phenomena described by Hugh just now. So at the junior end, there are a lot of girls, much more girls than boys. But then as the career progresses, the practitioners, they fall out and they go and do something else. They go and do easier jobs most of the time. I don't see many female practitioners, lawyers or arbitration counsel or arbitrators leaving the circle to take up even harder jobs or jobs that are even more challenging. Maybe there are very, very few exceptions where they become sort of executives of large corporations and heading a huge department. Those are exceptions. At the bar, for example, I see a lot of female practitioners hitting the age of, say, mid-40s, and then they will see a kind of dilemma in front of them because they have to decide whether their career is to progress even further, which entails their working even harder and showing people that they are working even harder and becoming even more ambitious, or they can choose to relax and maybe give more time to the family. And normally that is the excuse, the latter one. But it depends on the person. I mean, some ladies would very much like to see their career progress in the same way that a male barrister would like to progress to. When a barrister reach, say, 15 years practice, they will naturally consider whether it is for them to take silk to apply for appointment as a senior counsel. That is the junction where the lady will have to think very carefully. The lady will have to think about all sorts of factors that the men will not have to think about. I remember when I was considering whether I should be taking silk in 5 years' time, I had to think, oh, what is my husband going to think? You know, whether my children are going to think that I only care about my career and I don't want to give time to them, and so on and so forth. So these are the considerations that hardly any male barrister would ever think. They would only think, oh, my wife would want me to take silk because, you know, that shows that I'm good at what I do, and so on. But for a woman, various different considerations apply, and it depends on what sort of perception she feels there are about her progressing in her career within the family and within the circle that she belongs. And for ladies whose ambition cannot be suppressed by anything, I would very strongly advise them to make sure that people do not see you as slowing down. And sometimes it could be marked by an application to become a senior counsel. And even if you don't get it the first time or the second time, it's no skin off your nose, because a lot of people have to apply a second time or a third time. It doesn't mean that after you've been refused a second time, you're never going to get it. Not necessarily so. I was lucky to get it the first time, but I also see a lot of people getting it the second time and the third time. In the arbitration circle, likewise, you would want to be seen in circulation if you are serious about your career. If you are seen less and less, people forget about you, and then people who know you may think that, oh, maybe she has decided to slow down, when you are in fact not so deciding. And it would be unfortunate if it's just a matter of perception that you don't want to be pushing forward with your career, that you find yourself plateauing in your career. And that would be unfortunate. I think it happens with women. I make this observation, and a lot of people think that that's true. And that is, I see a lot of male colleagues who don't take silk or didn't manage to get it. Their practice is not going to fall because of they're not taking silk. But it only happens with the males. But for the females, if they don't take silk and they're not sort of stepping up into another position or as managing partner or something or other, they will be seen as slowing down naturally, unless there's evidence otherwise. So that is something that women will have to battle, I think. That you have to be aware of it, and you do things to make sure that people do not have that impression, if that is not the impression you would like to give.
I mean, the lesson really sounds like it is one of perseverance, and of course that's important, and that comes from oneself. But there is obviously another facet to assist, which is policy. And Winnie has recently been appointed as a head of Naval Chambers, and that brings neatly us to the question of, well, in terms of policy, has your chambers been implementing anything in particular that helps female practitioners, especially young female practitioners, advance their careers?
Well, in DVC, I'm happy to say that we have not found it necessary to consciously impose any policy in order to give equal opportunity to any particular sex, to any particular gender, because so far it has been a fairly equal battleground. We have taken in a lot of girls who are extremely bright, very, very good juniors. And in some year, the girls don't come and the boys are very good. And so we don't actually see that that's the case. And it should depend on merits rather than gender. We decided to just, pick people on the basis of merits. There has been years when there were more girls than boys. This year, I think there are more boys than girls. And we have maintained a fair equality at the junior end, I'm happy to say.
Well, that's very important, I think, regardless of...
For the Hong Kong Arbitration Center, I understand that there is a conscious effort to bring in more females as new arbitrators in particular.
Yes, I do...
Yes.
No, I do hear that many firms are considering gender when it comes to appointments, especially if it's two males to appoint a female, for instance, or try to very much. So I'm glad to hear that there has been a conscious effort on all parties. But bringing it beyond diversity, obviously, we would like to hear some advice as well as to how young arbitration practitioners who are looking to build a career in arbitration should conduct themselves. Are there any practical tips, sort of 2 or 3 things that you think they could really focus on in order to enhance their careers?
Yes. In the arbitration circle, I've only learned about how things operate in the past few years. To be honest, I remember 5 or 6 years ago, I was asking people, so what's HK45? What is this? and I found these things out bit by bit. I was a learner in this field. So it's been just for 5, 6 years, and it's a steep learning curve, but I'm enjoying every bit of it because I'm a sort of person who always likes to learn new things, and I would feel very bored and like I'm sort of going to hospital if I'm not in challenges and learning new things. So that is something which a young practitioner with aspirations of getting into the circle should really consider, should really consider. And that is to be in circulation for a start, and always learning something new in the area you're interested in. If it's arbitration, then you should be in a lot of seminars and getting to meet people. I mean, unfortunately, this COVID-19 has put a stop to all this. In the arbitration circle in particular, it is very important for people to be seen and in circulation, I think, and people there are some people who sort of go to every conference there is. I think that would be overdoing it, because you want to be also sitting down and doing a lot of desk work as well. But that is one thing, to be in circulation. The second thing, I think, is to try to find mentors in the field. If you're a barrister who is practicing independently and already, through pupillage and already in full practice, you would want to find practitioners who are very experienced, and you could offer to be either the secretary or some tag-along pupil or something, and that would enable you to get a taste of what arbitration is like and so on. And if you are offering to do that, you have to bear in mind, in some cases, unless you are trained and experienced as an arbitration secretary, you may not be able to expect a lot of pay in the job. And if you want to get into a new area, sometimes you will have to be conscious of the fact that you are given the opportunity and you are not asked to be a laborer in it because you have the skills and so on. So please do not feel that, oh, am I being exploited? Why am I getting so little money for what I'm doing, whereas other people are getting more than I do? I mean, it is very important not to have that sort of mindset and to be able to sort of offer yourself by way of learning as a learning experience. So I would advise that people interested in the area to offer themselves, sometimes even for free service. And that would definitely get you opportunities. And I have seen young members and young practitioners who are extremely good in doing that. And I think that they enjoy much more opportunities than others who would be thinking, oh, how many hours it's taken me to do this job, which I'm not getting paid a lot of money, or so on and so forth.
Perhaps asking a little bit more of a technical question, if time is limited, because obviously young practitioners have limited time only, which of the following three do you think is perhaps the most worthwhile endeavor? The first being writing articles or publishing, more generally, the second being attending seminars and really learning, and the third being attending social events, such as, not just social events, but conferences and networking events and so on. So if I had to pick between the three, which one would you suggest might be the most helpful?
Well, I think three includes two. I haven't seen any conferences that doesn't offer a seminar where you can learn, right?
Yeah.
So I would say three for that reason, because you're sort of doing networking as well as learning in sessions. For writing articles, that's a good thing to do, but only if you have been able to spend a lot of time and produce a really good piece of work. Now, there are a lot of arbitration publications in journals, in sort of newsletters of various firms, but not all of them would be even looked at by people who have the power to appoint you, you see? So, I mean, unless it is a really good piece of work that by itself, in its own merits, attracts attention, it really doesn't help you if your name is on an article, which is not particularly learned. So I would say it is much more productive to be seen and to mix and to have the opportunity to ask questions of people who are more experienced than you are, and hopefully to make an impression on people about how keen you are as a learner.
Yes. Well, that certainly sounds very important. And I think young practitioners will definitely bear that in mind. Perhaps moving on to slightly lighter topics, We also want to understand as a person how you sort of conduct the rest of your life, for instance, how you balance the demands of your career with your interests and your family. And that's important as practitioners move up as well, not to just be solely focused on their careers as well. Do you have any tips on how to strike the right balance?
It's always difficult to multitask if it is between family for a mother and a career which demands a lot of attention and energy. I have done a lot of the I have given up a lot of practice time in order to bring up the family. And when the kids have gone abroad, leaving an empty nest, I knew that it was time for me to make a change. And that was when I got into a lot of public work and work as a bar chairman and learning new trades, becoming interested in different areas of the law. And I think sometimes you need a break away from what you have been sort of very occupied in. And for example, this COVID-19 is a very good opportunity. I don't know how many of you have made use of this amazing opportunity to break away from what you have been doing every day for the last 10 years without the opportunity to catch a breath, to learning something new or having some breathing space so you can spend time with people you want to spend more time with and so on. So I think every time when there is such an opportunity, you will have to react very quickly and decide how to make use of it. When both my kids went abroad to study, I decided that I'm not going to just sit here and just or fly 5 times a year to go and see them. I did, but that didn't stop me from throwing myself into public work and professional work or work for professional organizations. And but even for that, I took on maybe too much because I find it hard to say no sometimes to something which I think really suits me, and appointments that really where I can make some contribution and at the same time learn something new myself. I find it hard to say no to those opportunities. As the years went by, I started to learn how to say no. So I turned away things that either really don't need me or things that I'm not very good at. And then I know how to choose between things that I'm better at and things that I'm no good at. And that way I learned to use my time more efficiently. I think it is very important that as you have more opportunities and more invitations to become this, that, and the other, you're able to tell between where you can really make a contribution passionately and where you would just be going, but you're not really passionate about it. And I think it is important to be able to choose between the two, because otherwise you'd be just all over the place, but not really making any contribution. Now, making contribution is a way to make your work satisfying. Unless you're making a contribution, these appointments will not begin to be satisfying. And you'll just find that it sucks all your time. It sucks out all your time, but you don't have time to do the work you should be doing, but you're still not making any contribution. And that would be very bad.
Yes. Obviously learning how to prioritize and saying no at the right occasion is, a trick that I think a lot of us need to learn how to execute. I noticed the time, so I want to encourage audiences to submit any questions you have. And so we can hear from you as well, and that's important for this dialogue. In the meantime, perhaps another slightly less strenuous question, which is that Moses mentioned that you have a great enjoyment of music and you sing very frequently, and we've heard you at Bar Association events singing previously. What 3 tracks would you recommend to our audiences that you listen to in stressful moments? Any in particular?
Well, I listen to opera sometimes. My daughter is a musician. I mean, she is in a very different kind of music production. So sometimes she drags me along to her gigs, and then I find that very relaxing. Although I have problems with the drum sometimes when it's too heavy. It sort of sends my pulses up, and I don't always enjoy that sort of music unless my daughter drags me along. But otherwise, I like listening to opera and orchestral music, symphonic music. I sing, but I hardly have a chance to sing these days because I don't have the time to practice. And this is something which I've made a wish to go back to do more in the future, maybe taking lessons once again, as I did when I was much younger. And because it is very, very difficult it's very, very beneficial for the body as well, for the lungs and the well-being of a person in general. So I would recommend singing to all of you, serious singing. If you like cabaret or musical, that's also very, very good. It doesn't have to be classical singing. Recently, I have been listening to French operas, and I have been spending some time learning the aria in Samson and Delilah, and I hope that it will be ready for my friends at entertainment in due course.
Well, we hope to have the opportunity to listen to that sometime at some Bar Association event as well. I suppose I'm looking to see if anyone has any questions, but it doesn't look like it. Perhaps if that's the case, we ask one last one, which is to ask what sort of future projects or plans do you have in the pipeline that we should be paying attention to?
Law or non-law?
Both.
For law, I've been drawn into eBram as a director, and I'm hoping to see that it takes flight. At the moment, it is trying to get ready to push out the service for the COVID-19 scheme, which some of you may have heard, announced by the Secretary for Justice, to give very cost-efficient dispute resolution means on the platform, online. To consumers. So it is like a few $100s for the resolution of any dispute. And that is going to be a prelude for commercial use of the platform for resolution of dispute, either through mediation, adjudication, or arbitration. And that is going to be very exciting. I think this will be a breakthrough in legal tech, and we hope to see it used in the region and in all sorts of countries. So that is the legal project. And for the non-legal project, I have just joined a reading club, and I'm very much looking forward to starting the sessions. And that is a reading club where we are reading classics and history. It is a very serious project, and I'm very pleased. And people think that they don't want to invite me because I'm too busy. They always think that. But as soon as I learned about it, I sort of volunteered. May I join, please? And I'm very excited. This kind of venture or undertaking makes me feel all the hard work is worthwhile, because then you can get a break and do something else. And I find it very refreshing.
Well, I'm very grateful to hear, or very interested to hear, that you have new projects coming in both in the legal sphere and also in your personal life. And I think that's wonderful. And that's something for all of us to bear in mind as well in our busy lives. I just wanted to end by thanking Winnie so much for joining us today and giving her time, and also to thank, of course, our colleagues from Hong Kong, the region and beyond, for joining us, and then HK45 as well for hosting this event. I just do a little bit of an ad. In 2 weeks' time, the 5th of our 6 webinars will be taking place. That will be with Justin Susan Crennan from Victoria, Australia. And then thereafter, we will be having Meg Kinnear from INSEAD as well. So do continue watching this space. Lots of very powerful and very well-meaning female practitioners joining us soon. Once again, thank you very much, all of you. Thank you, Winnie, and have a good weekend.
Thank you very much, Hugh.
Thank you.
Bye-bye. Thank you, everyone. Bye-bye.